Councilmember Wicks. And you have item number 24, AB 2223. Welcome.
Chair, what time are you going to recess?
We'll see how long this bill takes, but probably 5.
Thank you, Mr. Chair and members of the committee.
Yeah.
I want to start by thanking the committee staff for all her hard work. Melanie's been great on the bill, so thank you. In the past 2 decades, at least 1,300 pregnant people have been criminally prosecuted for having miscarriages or stillbirths or self-managing an abortion. California is not exempt from prosecuting individuals for their pregnancy outcomes. Despite clear law that ending or losing a pregnancy is not a crime, prosecutors in this state have charged people with homicide offenses for pregnancy loss. 2 examples are the case of Chelsea Becker and Adora Perez, 2 California women who were recently prosecuted and imprisoned for their stillbirths. Adora, in fact, was in prison for 4 years and was just released a couple months ago for having a stillbirth. To protect people's reproductive freedom and decision-making, AB 2223 will reinforce existing state protections to ensure that no one in California, whether you are a California resident or coming from out of state, will be prosecuted for ending a pregnancy or experiencing a pregnancy loss, whether it be stillbirth, miscarriage, or abortion. The same groups attacking abortion rights have spread disinformation about this bill. Therefore, I want to be clear about what this bill does and does not do. This bill protects against prosecution of pregnancy outcomes, including abortion, miscarriage, stillbirth, and perinatal death due to causes that occurred in utero. Here's what this bill won't do. AB 2223 will not prevent authorities from being able to investigate the facts of a newborn child's death, including whether the child was born living. This bill will only prevent further investigation of the pregnant person in the event that the death was determined to be a pregnancy-related cause that occurred in utero. It is designed to protect parents who experience the trauma of losing a child from being re-traumatized by unwarranted investigations. To be clear, this bill will not prevent police from investigating a fetal death that occurred as a result of a crime committed against a pregnant person. In addition, this bill does not diminish or change the ability of the state to intervene to protect a living child in instances of abuse or neglect, or from investigating an infant death that occurred as a result of an act or omission that took place after delivery. It is only focused on pregnancy outcomes and events that occur in utero. AB 2223 will remove outdated provisions requiring coroners to investigate certain pregnancy losses, clarify that the Reproductive Privacy Act prohibits criminalization of pregnancy loss and pregnancy outcomes, and create a private right of action for people whose rights have been violated. This bill is sponsored by leading organizations for reproductive justice, including the ACLU California Action, Black Women for Wellness Action Project, California Latinas for Reproductive Justice, If, When, How, Lawyering for Reproductive Justice, NARAL Pro-Choice California, Planned Parenthood of California, and many other organizations. Witnesses testifying in support, both will be testifying, I believe, by phone, are Dr. Selena Sandoval and Dr. Sarah Roberts.
All right, thanks very much, Dr. Wicks. Moderator, please bring it onto the line. Drs. Selena Sandoval and Dr. Sarah Roberts. You each have 2 minutes, maximum 4 minutes between the 2 of you. Let's begin with Dr. Selena Sandoval.
Thank you. Thank you, Dr. Pan, and members of this committee for allowing me to present today. My name is Dr. Selena Sandoval. I'm a board-certified OBGYN and complex family planning specialist. I'm here today to voice my support of AB 2223, which seeks to ensure that people are not criminalized for their pregnancy outcomes. Across the U.S., we are seeing a drastic rise in hostile legislation targeting those who can get pregnant with the goal of controlling their bodies and their reproductive choices. A woman in Texas was recently arrested for murder after she disclosed to hospital staff information that led them to believe she had self-managed an abortion. These charges were ultimately dropped, but only after a massive public outrage. And as shocking as this is, it is not exclusive to hostile states. In fact, this criminalization can and has occurred in California. We know that those who face criminalization for their pregnancy outcomes are disproportionately Black, Indigenous, and other people of color, LGBTQ+ people, young people, and those of low-income. Shamefully, the majority are reported by their own hospital staff. This post-Roe world creates an environment in which people will fear sharing potentially life-saving information with their providers due to concern for arrest. Pregnancy loss looks different for every patient. The medical community cannot always pinpoint what, if anything, led to a loss. And if the medical community cannot identify a reason, why would we expect that the justice system can? Because the symptoms of medication abortion taken orally are identical to that of spontaneous pregnancy loss, and there's no test to determine the difference, people experiencing early pregnancy loss are vulnerable to intrusive investigation and wrongful prosecution. We cannot allow this burden to fall on our patients. People who experience pregnancy loss are often experiencing pain, disbelief, and grief. Now within this toll, they are forced to fear prosecution. This is cruel, unjust, and traumatic. We must make it clear that people who can become pregnant in California will be safe and cared for, regardless of their pregnancy outcome. For these reasons, I urge and I vote. Thank you.
All right, Dr. Roberts, are you on the line?
Yes.
All right, please begin.
Good afternoon, Chair and members. My name is Dr. Sarah Roberts. I have a doctorate in public health, and I'm a professor at the University of California, San Francisco. I study the impacts of state-level abortion policies and policies related to pregnant people's use of alcohol and drugs, and have published more than 90 peer-reviewed articles about these topics. Public health policy should be guided by public health values and informed by the best available evidence. Criminalizing and prosecuting people for their pregnancy outcomes clearly violates core public health values of autonomy, privacy, and social justice. The evidence is very clear. Government interrogations and prosecutions of people for their behavior during pregnancy or for their pregnancy outcomes harms rather than helps health. I led a project in California where I interviewed pregnant and postpartum women who use alcohol and drugs about barriers to prenatal care. My research found that even though California law provides that a positive toxicology test is insufficient to establish child abuse or neglect, fear of jail or having their child taken from them led people to physically avoid and emotionally disengage from prenatal care. As one participant said, that whole time, that whole 9 months, you're like, I cannot go to this doctor because if I do, they're going to take my kid or put me in jail for the rest of my 9 months just to take the baby when I deliver. These fears are warranted given how often healthcare providers report birthing people use alcohol and drugs to government authorities. This reporting is deeply inequitable. Like other ways pregnancy is criminalized, Black women are 4 to 5 times more likely than white women to be reported to government authorities related to substance use during pregnancy, despite similar rates of use. We've also found that state policies that stigmatize and threaten to punish people's substance use contribute to thousands of babies born low birth weight or preterm each year. Public health values make it clear that limiting the threat of state retaliation for behavior during pregnancy is the right thing to do. And based on existing evidence, this is also important for public health. For these reasons, I urge your support on AB 2223. Thank you.
Thank you. All right, we'll now move on to additional witnesses in support of AB 2223 here in room 1200. Name, organization, position. Welcome.
Good afternoon. Molly Robeson with Planned Parenthood Affiliates of California. We are a co-sponsor and strong support. Thank you.
Thank you. Welcome.
Hello, Genesis Gonzalez on behalf of Lieutenant Governor Lenny Kanalakis in support. Thank you.
Thank you. Welcome.
Cindy Hillary on behalf of the California Medical Association in support.
Thank you. Welcome.
Ryan Spencer on behalf of the American College of OBGYNs District 9 in support.
Thank you. Welcome.
Erin Evans on behalf of NARAL Pro-Choice California, a proud co-sponsor of this measure, as well as the California Nurse Midwives Association in support. Thank you.
Thank you. Welcome.
Kimberly Robinson with Black Women for Wellness in support.
Thank you. Welcome.
Hello, Onyema Obiekia with Black Women for Wellness Action Project, proud co-sponsor of this bill, in support. Thank you.
Thank you. All right. Thanks very much. We'll now move to witnesses in opposition. We have Susan Arnell from the Right to Life League and Greg Burt from the California Family Council, 2 minutes each, 4 minutes total between two of you. Welcome.
I'm Susan Swift Arnall, California attorney and vice president of legal affairs at the Right to Life League, America's first pro-life organization. AB 2223 creates a host of unforeseen ramifications impacting state licensing requirements for reproductive health professionals or clinics. It creates a class of people immune from health regulations or investigation and nullifies born-alive protections in our state law. The bill goes much further than simply shielding mothers from prosecution for abortion. It uses the phrase, quote, notwithstanding any other law, a legal term of art that declares the legislative intent to override all contrary laws. The bill states, this is in Section B of number 7, A person who aids or assists a pregnant person in exercising their rights under this article shall not be subject to civil or criminal liability or penalty or otherwise be deprived of their rights based solely on their actions to aid or assist a pregnant person in exercising their rights under this article with the pregnant person's voluntary consent. This language potentially exempts anyone who aids or assists moms in childbirth or abortion from investigation or from licensing or professional requirements. So anyone can act as an unlicensed OBGYN, abortionist, or other clinical professional with impunity and without state oversight. If the state asks questions about the licensing, they can sue the state for $25,000 in attorney's fees for the threat of investigation. AB 2223 also permits infanticide following a botched abortion in direct contradiction to existing California Born Alive protection by providing immunity for a perinatal death due to, quote, causes that occurred in utero. That undefined phrase means that an infant born alive due to a botched abortion can be left to die over the course of days or weeks, so long as the abortionist points to a cause that occurred in utero. No coroner has a duty to investigate. AB 2223 creates a class of unaccountable, unregulated, unlicensed abortionists, totally immune from state oversight, regulation, investigation, or any legal scrutiny. AB 2223 is incompatible with existing laws protecting public health and should be rejected by this community. Thank you.
Thank you. I think she left you 1 minute and 29 seconds, 27, 8 seconds. Welcome.
Thank you. Chair and members, my name is Greg Burt with the California Family Council. Since AB 2223 was introduced, our organization has focused on how this bill moves the state beyond protecting abortion into protecting certain forms of infanticide. Despite claims that we were putting out false information, the bill has been amended twice to narrow the definition of perinatal death in response to these accusations. We believe the definition is still too vague, but I want to focus on another part of the bill that makes infanticide very hard to prosecute. AB 2223 says coroners will no longer be required to investigate the cause of death for self-induced or criminal abortion. But even more concerning is a provision you can find explained on page 2 of the bill analysis in paragraph 2. It says when a coroner's job does their job and determines the cause of death of a newborn, any evidence of a crime the coroner finds can't be used, and I quote, to establish, bring, or support a criminal prosecution or civil action seeking damage against any person, whether or not the person who was pregnant with the fetus. So if the coroner finds evidence that the cause of death was criminal, maybe infanticide by suffocation or neglect or drowning, that cannot be used to prosecute anyone for a crime. My question is why? Why is that provision in AB 2223 if not to make infanticide nearly impossible to prosecute?
Time's over. Time's up.
Thanks.
Thank you. Thank you so much, sir. Other witnesses in opposition to AB 2223, name, organization, position only. Welcome.
Max Graves, Liberty Life Center, Liberty Baptist Church, End Abortion, California. I strongly oppose this bill.
Thank you.
Murder.
Thank you. Welcome.
Leslie Graves, Liberty Baptist Church, Liberty Life Center, Liberty Baptist Academy. I strongly oppose.
Thank you. Welcome.
Pastor Max Graves, Liberty Baptist Church, Norwalk, California, Director of the Liberty Life Center, and also End Abortion Now Director, End Abortion California Director, strongly oppose this iniquitous bill.
Thank you. Welcome.
Catherine McBride, speaking on behalf of the 63.5 million babies that have been sacrificed since 1973 when Roe versus Wade
Name, organization,
passed.
position.
Yeah. The organization is in support, in honor of the 63.5 million children who have been sacrificed. And I respectfully ask for your no vote on AB 2223. Thank you.
Thank you. Welcome.
My name's Erin Jasper. I'm with Liberty Baptist Church, Liberty Baptist Academy, and Jasper Preparatory Academy, and I vehemently oppose this abomination to God's law.
Thank you. Next witness. welcome.
Alexia Jasper with Liberty Life Center, Liberty Baptist Academy, and Liberty Baptist Church, and I strongly oppose this bill.
Thank you. Welcome.
Ella Graves with Liberty Baptist Academy, Liberty Baptist Church, and Liberty Life Center. I strongly oppose this bill.
Thank you. Welcome.
Joy Jasper with Pacific Baptist School, and I oppose this bill.
Thank you. Welcome.
Thank you. Gabrielle Ingram, founder of Stand Up Sacramento. Even with the amendments, we oppose the bill.
Thank you. Welcome.
Hello, Kasia Williams, Ladies of Liberty, asking for a no vote. Thank you.
All right, thank you. Welcome.
Jonathan Keller with California Family Council, also representing the California Southern Baptist Convention, requesting a no vote.
All right, thank you. All right, thank you. Let's bring it back to the committee. Questions or comments from committee members? Senator Melendez.
Thank you, Mr. Chairman. So, Assemblymember Wicks, I have several questions. First of all, in the bill, in the digest, it talks, or it speaks to, the bill would delete the requirement that a coroner hold inquests for deaths related to or following known or suspected self-induced or criminal abortion. What is a criminal abortion?
If I may, Mr. Chair, I also have legal counsel for technical questions. Ruth Dawson is line 161. Would you mind if we pull her in?
Sure.
Okay.
Yes,
She's a lawyer, so.
Yes, so please bring in, you said, what's her name again?
Ruth Dawson.
Ruth Dawson, please.
161.
You don't know what a criminal abortion is?
I just want to make
I
sure.
know.
I'd prefer you talk to a lawyer who has more expertise in this.
So please bring in Ruth Dawson on the line. Okay. All right. Okay. Fortunately, I don't think she's available at the moment. Is there a way we can?
So can you answer the question?
Can you just give me 1 second,
Hold on.
please?
Wait a minute. Do you want to get your question answered?
I just don't want to misspeak.
Are you someone communicating to get her on the line?
It's, can you ask the,
moderator.
I'll tell you what, I'll move on.
Okay,
I'll move
all
on,
right.
and perhaps during that time
Actually,
period,
moderator, if
we
you
can
could
get her
try
on
to
the line.
find Ruth Dawson while we're waiting. Okay.
Okay,
please continue.
so, thank you, Mr. Chairman. So you amended your bill. You took out the part that said due to pregnancy-related causes, and you changed that to causes that occurred in utero. So, one of my main concerns with this bill is that your bill seems to overrule any other current laws. And I think one of the witnesses spoke to that. In the bill where it says, notwithstanding any other law, a person shall not be subject to civil or criminal liability or penalty. Notwithstanding any other law means this law, were it to go into effect, supersedes any other laws that are on the books today. Is that your understanding of it?
My understanding is the goal of this bill is to clarify that pregnancy loss of any kind cannot be criminalized.
Okay,
and to further.
But the bill says, notwithstanding any other law, and the, let's see. So from the California Court of Appeals actually weighed in on that particular term.
And by the way, just, sorry, I heard that they won't unmute her line. She's line 160.
Okay, well, let me continue with my question.
Pardon the interruption. This is the AT&T operator. We believe we may have the line right now.
Okay.
And I'm going to open her line.
No.
Here,
I'm in the
please.
middle of a question here, so that's going to have to wait.
Sure.
Sorry. Well, we'll have her wait, but
Thank
we'll
you.
be sure she's available.
Okay, so the California Court of Appeals explained in the case Classic versus Castaic Lake Water Agency, it says, and this is the California Court of Appeals, notwithstanding means without prevention or obstruction from or by, or in spite of, or despite. The statutory phrase, notwithstanding any other law, has been called a term of art that declares the legislative intent to override all contrary law. By use of this term, the legislature expresses its intent to have the specific statute control despite the existence of any other law which might otherwise govern. So, in your bill, it says notwithstanding any other law, which means it supersedes and takes precedence over any other laws we have on the books. Okay? So, in that particular case, then that opens up a whole host of issues. You have many people who are concerned that this bill would allow for the killing of an infant or the neglect of an infant, which would then result in the infant's death. When it comes to abortion, I'm sure you are well aware that there are failed abortions, and there are times when an infant is born alive after an attempt at an abortion. Yes?
The purpose of the bill.
I'm not
is to ensure
asking you,
that
I am not asking, I know what your purpose of the bill is. I'm just asking you, and let's have an honest conversation here about what takes place, okay? You are aware, I'm hoping that you have, done your homework on this issue beyond your own personal interest in getting the bill passed and understanding that there are times when an infant, a baby is born after a failed abortion attempt. If you're not, I encourage you to Google Kermit Gosnell, okay, who went to prison because he was allowing babies to be born alive and then putting them in a bucket and sticking them in a utility closet. 47 different bodies they found in that clinic. The investigators found that they couldn't determine whether the cause of death was in utero or afterwards. So it's a difficult thing to prove that something was caused in utero. That is already established science. So, how do you assure people that babies that are born alive or babies that are induced at a viable age that then die because their care is neglected, much like Governor Northam of Virginia stated would happen in his state, that a discussion would take place while they kept the baby comfortable, and then the discussion would be, what should we do about this baby? Should we let it live or should we let it die? I don't know what is so funny that you keep smirking at, but this is a very serious issue. We're talking about lives. So, what can you do to assure people that that would not happen? Because your bill very clearly is worded in a way that supersedes current law.
So I want to defer to our lawyers, Ruth, who's on 161, and also one of our doctors. I think Dr. Roberts might be able to answer those questions to make sure that they give you the information you need, because I'm not a doctor nor a lawyer.
Okay, and actually, I'd urge everyone to try to keep the remarks brief because we are coming about the time when we need to close down this hearing. So, please answer. So, which you wanted.
Yes, if Ruth could answer the legal questions that
please.
the senator asked, and then Dr. Roberts could weigh in on the medical questions.
Hello, can you hear me?
Yes, please go on.
Wonderful. Thank you so much. My name is Ruth Jocelyn. I'm with the ACLU of California. So I'm looking at the definition in the Reproductive Privacy Act, Health and Safety Code 123468 states that the performance of an abortion is unauthorized if either of the following are true, and then less circumstances in which
my question was, what is a criminal abortion, not what is an unauthorized abortion? What is a criminal abortion?
I hear you. Thank you. It is my understanding, Senator, that is an outdated term, and that is part of the reason that portion regarding coroners is being cleaned up. So I'm happy to read to you currently in the Reproductive Privacy Act.
No, that won't be necessary. Thank you. That won't be necessary. Thank you. We are in limited time here. I want to get to the heart of the matters here, but thank you so much. Was there something else that she was going to answer, or just that one?
For legal questions.
Was there someone?
And Dr. Roberts is a doctor who I think can help answer your medical questions.
Thank you. Is he on the line?
She, yeah.
She, sorry.
Dr. Roberts still on the line.
This is Dr. Roberts. I'm actually the public health researcher. The physician is Dr. Sandoval, and I believe she is here.
Okay, Dr. Sandoval. Again, please try to be brief.
Dr. Sandoval, can you? Yeah, if you could please repeat the question that's related to my medical expertise.
You've got to be kidding me. Okay, you know what? We're going to continue because I'm not going to go back through. I mean, I had a whole litany of things here that we spoke about, and she can't remember what I asked. So, again, I want to know what you can do to assure us that an infant is not going to be allowed to die after being prematurely born, whether that's by induction or something else, and that this law wouldn't shield the person who helped her do that, or...
This law is, if you want to finish.
Yeah, go ahead.
This law is specific to perinatal death due to causes that occur in utero.
Mm-hmm. So if
a child is born.
Yes.
And comes out of the womb and is a healthy, or if not, a living person, they have those rights. And if something happens after birth, where there's some sort of malpractice or homicide or anything to that nature, after the baby is born, then they can certainly be investigated by investigators.
How can they be investigated if your bill says that it can't be investigated? Your bill says that you cannot, that the coroner can't conduct an inquest.
This bill does not prevent police from investigating a fetal death that was occurred as a result of a crime.
Are police,
occurred to
are law enforcement really qualified to do that type of investigation, or is that something that more suitable to a coroner?
The doctors still make the medical determination.
Correct.
Yes. So they have a process to make that determination. And if the medical determination is that someone did something to harm a baby, and it wasn't a stillbirth, it can still be investigated based on those medical determinations.
That is not what your bill says.
And this is where I would love to have Dr. Sandoval speak to this.
But it's your bill.
I understand, but she is a doctor. I'm telling you what my bill does.
You're the legislator. It's your bill. This was your idea, and I'm telling you.
And I just told you my answer.
Your bill says that the cause of death can be placed on the death certificate, but it cannot be investigated. The coroner may not start an inquest.
If a doctor determines that there's something that needs to be investigated, an investigation can be triggered.
By whom? Your bill says it can't be done. It very clearly says you cannot do that.
After a baby is born, if some sort of malpractice happens, that can be investigated. If something happens in utero and there's a stillbirth, then a doctor would have to determine if there was some.
Where in your bill does it say it can still be investigated?
Well, it sounds like we have a different opinion about what the bill says.
We just have a different opinion.
Well, we are debating a bill.
What section?
Okay.
Code section.
This says the coroner
also in the judiciary
certificate
analysis
on the fetal death, but it says it cannot be used to establish, bring, or support a criminal prosecution or civil cause of action. That's what it says.
And I think Ruth can answer some of these questions too, as the lawyer.
Okay, can we bring on Sandoval to answer the questions?
They just need to unmute Ruth.
Okay, can you please unmute? Moderator, please
Yes. Hi, folks. So currently, coroners have a statutory duty to investigate unattended stillbirths. Stillbirths that don't happen under the attendance of a physician, or, quote, self-induced or criminal abortions, unquote, even though, as I mentioned earlier, none of these are currently crimes under California law. There is no specific requirement that healthcare providers report stillbirths or abortions to the coroner's office. But nonetheless, there is confusion about the intersections of these existing requirements, which has led to hospitals turning their patients over to law enforcement, and that's what we're seeking to repeal with this bill.
Well, thank you.
Coroners will continue to investigate alleged crimes. Mm-hmm.
Yeah, I appreciate you reading to me the documents that I have in front of me, but I'm still not getting an answer to my question. Because this bill says, notwithstanding any other law, a person shall not be subject to criminal or civil liability or penalty or otherwise deprived of their rights under this article based on their actions or omissions, in other words, neglect, leave the baby there to die, with respect to their pregnancy or actual, potential, or alleged pregnancy outcome, including miscarriage, stillbirth, or abortion, and including miscarriage, not limited to, but including miscarriage, stillbirth, or abortion, or perinatal death due to a pregnancy-related, or due to a cause in utero. So where in this bill does it say that you can investigate the death of an infant?
I believe the judiciary analysis points to this.
Great, read it to me.
I don't have it on me.
Okay, we're here debating and vetting this bill, and you're not prepared to answer the questions, and this is of monumental importance.
Respectfully, I think we have a difference of opinion on this.
No,
and
we
I
don't
can
have a difference
discuss
of
with you
opinion.
The intent of what we're trying to do. We've had women in the state of California imprisoned for stillbirths.
And they were released.
After 4 years.
They were still released, though, weren't they?
After 4 years.
Okay, but your bill doesn't talk about criminalizing someone just on the basis of being penalized for a stillbirth. You have gone far beyond the boundaries of that, and you are talking about, in any circumstance, you cannot investigate the death of an infant. If under any circumstances, as long as it was a self-managed abortion or miscarriage, stillbirth, and you can't even investigate the person who helped her do it.
If there was any, again, I'll repeat, if a baby is born, after the baby is born, full investigations can take place. If there's something that happens in utero, we're trying to clarify the language.
Your bill says otherwise, and I'm asking you, I'm begging you, show me, point to me what part of the bill says where it is in the bill that this can be done. That's all I'm asking.
Right.
Where in the bill does it say it can be done?
Senator, I believe she's answered your question.
She hasn't answered my question.
I believe she has answered your question.
She hasn't answered my question.
Hold on.
Sorry,
hold on,
and I just
hold
have
on.
a clarification.
She hasn't answered my question.
Order. It's up to her to decide how she wants to answer your question. If you're unsatisfied with her answer.
No, I would be satisfied for any answer.
Okay. So I believe she has answered your question.
No, she has not. I just want to know. Tell me what section of the bill says that you can investigate the death of an infant.
So you have asked that question multiple times.
And I haven't gotten an answer.
And she has given you an answer. You may not be satisfied with it.
No, she hasn't. No, she has not.
I'm sorry,
So
Mr.
there's a
Chair.
point of order. Which
So,
okay, hold on.
Mr. Chair, I missed that answer, and you said you heard it. So
sorry.
what was the answer? What section of the bill is it in?
So hold on.
So,
so first of all, we have a point of
thank
order.
you. So I just want to clarify that I have heard the author give an answer.
Okay.
It's not an answer, right, that everybody
That's not a point of order.
All right, that's not exactly, hold on.
I'm sorry.
So anyway, it is,
section?
she has given an answer. You may not be satisfied with the answer. All right, but we need to move on. And so let's
okay.
Perhaps you can ask.
I'm not.
You've asked the same question multiple times, and she has given.
Okay, I'll move on.
Answer. So
but
thank
this
you.
is an important bill, and it's just unfathomable to me that we would try to rush through it. A bill of this significance, we're going to say, hurry up because we need to go somewhere else. This is just unbelievable. Okay, your bill talks about, I guess she's not listening. Okay. Your bill talks about causes that took place in utero. So if a baby is, because remember, this legislature, your party, has decided to invite people to California to have abortions, okay? So we have become the abortion sanctuary state. That was the governor's words, not mine. So in doing so, do you not think that there is going to be a surge of those who are wishing to provide abortion services, and that some of those people may not be operating within the confines of the law? And then your bill will allow them to be shielded from the law. So if you have an infant, or I'm sorry, if you have a woman who is pregnant and if you have, let's say she's gives birth and the baby is living, okay? Your bill, I don't see anywhere in here where it says you would have to provide that infant care, because if, let's say, okay, let's go a step further. So an abortion is attempted, because your bill contemplates that, right? And an intended abortion, perhaps it was a failed effort. So, but now the baby was injured in utero during this process. The baby is now out of the mother's womb, and your bill basically says that you don't have to provide it any care.
Provide the baby any care?
Correct.
I'm sorry, I don't understand the question.
Your bill says that you can't be criminally liable for not providing care. I'll read it to you directly from your bill. A person, well, we'll talk about the mother too, cannot be deprived of their rights, cannot be held liable based on their actions. So,
I'm sorry, are you referring to if the baby is born? I'm just a little confused by the question.
Based on their actions or omissions with respect to their pregnancy. Why is my microphone turned off? Or actions or omissions, so action perhaps meaning the abortion, or omission being the neglect of care with respect to their pregnancy, or actual, potential, or alleged pregnancy outcome. So
They're cutting you off.
The bill says that you don't have to provide care.
Point of order, Mr. Chair. We need to take a recess.
Okay, thank you.
No.
Can I just answer that actually? Can I tell you what the bill actually says?
So,
Well, I have it in front of me.
So unfortunately, we do need to recess.
We can't finish the bill?
No, we're not going to be able to finish the bill right now. We need to take a recess, and then we can come back, and then we'll decide whether we hold this over for tomorrow or we wrap this up today. So we do have to take a recess. So
Mr. Chairman, if I could just make a point respectfully to my colleague. The author has been continually interrupted this whole time.
Senator Wiener, actually, this hearing of the Senate Committee on Health will now be in recess. Thank you.
It's okay. Okay.
Item number 1, AB 2223, was already heard in terms of public comment, so we will only be taking member comments and questions on item number 1, AB 2223, and then we'll also then we have 2 additional items to address as well. So with that, let's go ahead and establish a quorum. Secretary, please call the roll to establish the quorum.
Han?
Here.
Han here. Melendez? Here. Melendez here. Eggman? Here. Eggman here. Gonzalez? Grove? Here. Grove here. Hurtado? Leyva? Limon? Here. Limon here. Roth? Here. Roth here. Rubio? Wiener? Here. Wiener here.
Okay. Thank you. A quorum is established. So we're going to begin with what is now item number 1, AB 2223, with Assemblymember Wicks. Again, as I mentioned, public comment was already taken yesterday, so we will now just be returning to member questions and comments. I will just make note that again, we need to maintain decorum here in the committee, and so let's now open again AB 2223 for member questions or comment.
Has there been a motion to move the bill yet?
I have a comment.
Okay, I do not. Is there a motion? Okay, it's been moved by Sarah Eggman. All right, questions or comments, Senator Melendez.
Thank you, Mr. Chairman. Okay, so let's reconvene. This bill says that an inquest, an inquiry, an investigation into a death of an infant doesn't have to happen. So I'm trying to understand how we can make sure that nothing illegal took place with the death of a child if an inquiry doesn't take place, because there is a fine associated with conducting an investigation. So there is the threat of being sued. So it's going to be difficult to imagine a situation where these investigations are going to take place on a regular basis because there is the threat of being sued. So if there's the threat of being sued, if you just even look into the cause of death, not necessarily bring charges, but look into the cause of death, then less investigations will take place, which means there are going to be many cases where we have no idea why the baby died.
A medical doctor can prompt a coroner's investigation should they determine the need to do so.
Okay, but it says that if you do that, you can be sued for that. And so then we go back to what we talked about yesterday, which was the difficulty in determining if something happened to that baby in utero or after the baby was born, which can be difficult, to determine. I mean, there are cases where doctors have just said, we can't make a conclusive determination.
So coroners will continue to investigate alleged crimes. If a baby is born alive, that is now a person who has rights. And if something happens to that baby where they are harmed or injured or, God forsaken, murdered, the coroners will be able to investigate that. Law enforcement will be able to investigate this. That bill changes none of this.
Well, I understand what you're saying in that the bill doesn't prohibit an investigation. It just says it's not required. But again, the concern is the threat of a lawsuit, which means we will likely have, do you have any concerns about that? That there may be, coroners who choose not to do the investigation for fear of being sued?
I do not have that concern.
You don't have that concern. So, okay, then moving on.
And I would also say, if the coroners had that concern, they would oppose the bill, and they're not.
So then let's move on to the section that talks about not using anything on the death certificate in bringing civil or criminal charges against either the mother or anyone who assisted her. So if you can't use the cause of death in a criminal matter, then how do we stop people who are not supposed to be performing abortions or who did so illegally, because the bill does talk about criminal abortions? How do we stop them from operating if no charges can be brought against them, or the cause is not allowed to be used in a criminal matter?
If I may, Mr. Chair?
Yes, Chair.
We have legal counsel from both Planned Parenthood and ACLU here today as expert witnesses.
All right, if they wish to approach and provide an answer to Senator Melendez.
Good morning, Ruth with the ACLU of California Action. Thank you for having us today. So this bill does not change the threshold for when a coroner can craft a fetal death certificate. Health and Safety Code 103005 in the bill says that the certificate cannot be used to prosecute someone who's immune from liability in this particular section, 123467. So gathering information about the causes of pregnancy loss is an important component of addressing longstanding crisis in maternal and infant outcomes for Black, Indigenous, and other people of color. And this bill does not change the requirement of public health reporting of fetal deaths under the pertinent health and safety code, and thus doesn't interfere with the collection of that data.
All right, thank you.
Okay, thank you for clarifying that. However, that brings us back to where it says in the bill that you can gather the information, but you can't use that for any sort of criminal charges. So it doesn't really do you any good if you can determine that something nefarious took place if you're not allowed to actually use that, right?
Well, do you want to address that?
Sure. So also to take a step back, the question you asked earlier about criminal abortion, that is actually an outdated term, which is part of why this bill is a cleanup bill, because that is outdated language which remains in statute. So that does not currently exist under California law. The Reproductive Privacy Act is what determines what abortions are authorized in this state, and this bill does not change what abortions are authorized. Would you repeat your exact question for me?
Sure.
Thank you.
My concern is that the bill says you cannot use the cause of death as a reason for a criminal case, for bringing a criminal case or prosecution. So I'm just wondering how we keep people who are not supposed to be engaging in providing abortions, how then, where's the punishment for if they decide to do so? Because this says you can't bring You can't use the cause of death. Let's say, person A is the one who performed the unauthorized or criminal abortion, whichever one you want to call it. Both are in the bill. So they do this, but the bill says you can't, and the inquiry has determined that, but the bill says you can't use that for a criminal case.
So the language in this bill protects people who are exercising their rights under the statute and those who help them. And so there are several points, if I can draw your attention to the section 1, 2, 3, 4, 6, 7. This language is pertinent only to a pregnant person in section A. Its intention is to make clear to actors like former District Attorney Fagundes in Kings County that California does not permit criminalization of pregnant people. Yesterday you mentioned the notwithstanding clause. That clause does not invalidate other laws that would apply to someone other than the pregnant person, such as someone who commits an offense against a pregnant person.
Okay, hold on. If I could stop you.
Sure.
Well, I just want to drill down on that particular bit, if that's okay.
Okay, well, I just want to be sure did you finish answering the question?
Okay, no, that's all right. If you want to continue your thought, go ahead. We'll come back to it.
So the term notwithstanding only applies to that subsection A, not B. A pertains to the pregnant person. So as I mentioned, if anybody, such as a prosecutor, seems to think that a law applies that would criminalize a pregnant person for their pregnancy outcome, this phrase makes it perfectly clear that the law does not. I'll also note that that section is limited to, quote, rights under this article, which are found in the statute, and that pertains to, quote, all matters relating to pregnancy, including prenatal care, childbirth, postpartum care, contraception, sterilization, abortion care, miscarriage management, and infertility care. So section A is cabined and limited. Further, though I note it does not contain the term notwithstanding, which was brought up yesterday, section B is also limited in several ways. So first, again, this section is limited to someone who aids or assists a pregnant person in exercising only their rights under this article, so limitation. And the section is further limited to based solely on their actions to aid or assist a pregnant person in exercising their rights under this article. And finally, this protection is all contingent on the pregnant person's voluntary consent. That is language in the statute as well. So any unconsented, negligent, or otherwise unlawful acts, like those that don't comply under 1, 2, 3, 4, 6, 8, which is our what abortions are authorized, are still subject to other liability and laws.
Thank you.
Okay, but in section 1, 2, 3, 4, 6, 7, where subsection A, where it says notwithstanding any other law, the person shall not be subject to civil or criminal liability. I'm not understanding why you say that that does not pertain to an abortion that is considered illegal or unauthorized. Because it says notwithstanding any other law, so that supersedes any other laws that we have on the book, so.
I believe
And that
you
only
addressed that
pertains
issue.
to the person who is pregnant.
Right, so if it's the person who's pregnant, and she gets an illegal or criminal abortion, then this says she can't be held liable or criminally charged.
That is correct. And law in California is clear that ending or losing a pregnancy is not a crime. And in fact,
well, it is if it's a viable fetus. It is a crime.
I'll refer you to the Attorney General's legal alert, which came out January of last year.
Right, but I don't think his legal alert said that you can't be charged with a crime if you get an abortion at any point in your pregnancy. I don't think that's what it said. Or did it?
So this bill does not change which abortions are authorized or unauthorized under California law. That part of the Reproductive Privacy Act remains as it is written.
Okay, but it says notwithstanding any other law. So even with section 187, which the AG addressed, and where he said this does not pertain to a woman getting an abortion, the intent, I as I understand it, wasn't to indemnify an abortion at any point in the pregnancy. It was only for those abortions that are authorized. In other words, prior to viability or done by somebody who is legally allowed to do so. But this section says otherwise.
I respectfully disagree, Senator. So that section A is limited to rights under this article. You are correct. And so rights that are already provided for under the Reproductive Privacy Act would be covered by Section A, but it does not expand the rights that are covered. And I think, did you want to?
Okay, well, we're going to have to agree to disagree because I don't understand it that way, and the attorneys I've spoken with don't understand it that way, and the judges I've spoken with don't understand it that way, and I'm going to guess the opponents don't understand it that way either. But I would ask that if we're going to have the support witnesses comment on this, are we also going to allow the opposition witnesses to comment as well?
Well, did you have a question for them?
Sure. Yeah.
Okay.
I mean, I just want to make sure.
If I can clarify too, there is no statute in current law that criminalizes a pregnant person.
No,
the statutes currently regarding what is authorized for, in terms of performing an abortion, relate to clinicians, and those laws all remain in effect.
Okay. No, okay, that's not what I was asking, but I will defer. I know she has some questions, so.
Okay, thank you. Senator Grove?
Thank you. Thank you. When I look at your bill and it talks about on section 7, line 29, it says on section 7, line 29, or you can go just a few lines up, or you can start on 24. Notwithstanding any other law, a person shall not be subject to civil or criminal liability or penalty or otherwise deprived of the rights under the article based on the actions or omissions with respect to their pregnancy or actual potential or alleged pregnancy outcomes, including miscarriage, stillbirth, or abortion, or perinatal death due to causes occurred in utero. So that last sentence is what I want to ask you about. I was looking under definitions, and if you could point me to it, it would probably be faster. Can you tell me the definition of perinatal death?
Well, I'm glad you raised this last bit. We wanted to clarify the intent of the bill, right? Is that if something happens in utero, that and it causes a unfortunate circumstance where the fetus is lost essentially or doesn't make it, this would ensure that the mother is not held criminally prosecuted for that act, right? And so an example of that, and we've seen this happen, there was a woman who was driving. She was about 8.5 months pregnant. She wasn't wearing her seatbelt, got in a horrific car accident. They had to induce, perform a C-section. The baby died, and she was criminally prosecuted for that. And so this bill will protect against those types of circumstances. And I'm happy to defer to our legal counsel if you want more specificity on the definition.
So the only thing I'm asking for is I couldn't find, usually in these bills that we produce, it says definition of, labor, not labor as in labor and delivery, but any type of bill, there's definitions. And I couldn't find that section in your bill. So that's why I think it's very vague. And so I'm just trying to find out the definition. I mean, I understand what a stillbirth is. I understand what, let me go back to that code section. I understand miscarriage, stillbirth, or abortion. I understand that. But there is or perinatal death due to causes occurred in utero. So my question to you, because there's no definitions in your bill, it's so broad, you get several different definitions. Where's the definition of perinatal death in your bill? Or can you tell me what your intent is?
I think I just explained my intent, and in utero, if something happens in utero.
Right.
Okay, so just to let you know where I'm
let me
coming
also
from,
just add, by the way,
I'm not trying to argue. I'm really not. Go ahead. I didn't mean to.
I was going to say, and we actually worked pretty closely with the Catholic Conference on this, and worked closely with them, and they came off opposition because we clarified the intent of exactly what you're asking right now.
Okay, yeah. I appreciate that. I think the Catholic Conference is wrong. We've replied to their withdraw, but they have the position on the bill. This is why I'm asking you this particular question. If you look at, do you know what the World Health Organization is?
Yes, I know what the World Health Organization is.
Well, I mean, I was just making sure. So the World Health Organization in perinatal death says that it's a baby between 22 weeks of gestation or weighing 500 grams or 7 days after birth. So I guess my concern with the bill is if this perinatal period is 7 days after birth and you have a botched abortion where you have a viable baby that's alive, where you said in previous responses to Ms. Melendez that your intent was not, that baby has rights. You said that. That was some of your comments. But if the World Health Organization is used by some slick attorney, the definition, that's a credible organization. Do you agree or not?
The World Health Organization, yes.
Okay. So the World Health Organization says, again, 22 weeks of gestation, 500 grams, or 7 days after birth. So I guess my question is that if somebody was to take your bill and say, you know what, the World Health Organization says this is a perinatal death in utero, that's what your bill says. How long, I mean, they would actually have up to 7 days to neglect the baby, let it lay there for 7 days, starve for 7 days, stabbed to death for 7 days, and under your bill, there'd be no investigation whatsoever. Is that
just not true.
Not true.
Yeah, I mean, again, I'll repeat the same thing I've said a couple times now.
Okay.
If a baby is born and is alive, if there's any neglect, abuse, anything that results in that baby dying or being harmed, there should be an investigation.
Okay, so I get you're saying that. I do, and you've said the same thing to Ms. Melendez. Okay. But this is the problem. Just a little leeway, Mr. Chair. This is the problem. There's no definition in your bill to define what perinatal death is. The World Health Organization has its definition. Your intent, and I believe you when you say your intent is to make sure that infant death is investigated if the baby is born alive, okay? We all get that it's about abortion, miscarriages, not prosecuting women who lose their babies like you just described with the lady of the seatbelt. I understand what you're saying, but that's what we're trying to convey to you is that's not what the bill says. The bill does not give a definition, or I haven't found it. So if you could point to it.
In utero, is clarifying the language.
So,
to answer your question.
Can you give me, show me in what page or section your bill says the definition of perinatal death in utero?
So I think she answered the question, and so if you wanted to comment on her answer, that's fine. And I know that you're expressing your disagreement or your feeling that her answer is not meeting it, but I think she did answer the question that you asked.
Okay, so since the chair is a doctor, and he understands that you answered the question, can you tell me where the definition is that says in utero, perinatal death in utero?
Well, that's what the bill says. The bill says perinatal death in utero.
But can you tell me where that's at?
You just read it.
No, but it's
the bill.
The definition. My question, Mr. Chair, was what's the definition of perinatal death in utero? Well, and you said she answered it, so I didn't catch it, but I'm not a doctor either. Okay. So I'm asking you as the chair, as a doctor, where is that at? Where's the definition perinatal death in utero?
Well, I think let's put it this way. Okay. So we're not having a back and forth.
Yes.
And again, you can disagree. All right. I'm just saying that the word in utero means in the uterus.
Yeah, we know that.
So right. Yeah. So that's what it says. So it says in the uterus. So if it's not in uterus, then it's not in utero anymore.
Correct.
So you can shove a coat hanger?
Yeah, I guess. I don't know. Okay. Are you aware of a legal definition or a code section that references any definition other than what I found about the perinatal death for causes in utero? Are you aware?
We clarified perinatal by adding in utero to make it clear that if something happens to the fetus while it's in utero, that results in the fetus dying, that the person cannot be criminally prosecuted for that. So in utero was added to clarify the intent around what we meant around perinatal.
Okay, so.
Which we worked with, the Gynecologists Association, the midwives, and many others to clarify this in a way.
Like precedents, is
as
there
well as
something
Planned
out
Parenthood
there?
and others.
Can you point to anything that gives a definition of that statement?
All right, I think she's answered the question.
Is it just no?
multiple
Just, it's
times.
no, there's nothing
In
else?
utero is the we're adding clarity to perinatal by adding in utero. That is the clarity we
Okay.
sought to add.
Okay. Under this bill, there's also civil and criminal liability, which was discussed for any person aiding or assisting that person who self-performs an abortion and withholds care from the infant if it's born alive. That's how we see it, but that's not how you see it. So the answer is no.
Sorry, what is the question?
The question is, under the bill, I understand it to be that there's criminal or civil liability for a woman or any aiding or person assisting.
Like a medical provider?
Or, your language says any person aiding or abetting. So I'm assuming it can't be, it doesn't have to be a medical provider based on your bill, right?
So every medical provider is licensed by an oversight agency in California that has to adhere to the scope of practice or the standard of care of the regulatory board. So there's oversight amongst all of our medical providers here, and that this law does not change any of that.
Okay. When you look at the $25,000 penalty in that section, I'm looking for it right now. It says any person that assists. So it doesn't say any medical person or any licensed person or any doctor or any abortion provider or any, it doesn't say that. It says any person who assists, right? That's what it says. I'm looking for it.
All right.
And Mr. Chair, if we could get clarity from legal counsel here.
Okay, from the sponsor.
Hi there. I believe you're again referring to section 123467B. Is that true?
B, this section should not be used to establish or bring support criminal prosecution civil action seeking damages against any, it's line through person, any person who is immune from liability under this section. So it says any person. It doesn't say doctor or.
Yeah, so this section is limited in several ways, as I mentioned before. So
can I, Mr. Chair, do I get to pick my witness to ask that question? I'd like to ask the opposition attorney that question, if that's okay with you. Thank you. Could I have you come up?
Okay.
Sorry, I don't know your name. I apologize. So this is my question, okay? And please don't go off on some, like we've heard before with like these long legal ramblings. It says that basically, this is what it's, I won't say basically, I'll say. So there's a $25,000 penalty for anybody who assists in prosecuting this person, this mother it says there's part of it that says in utero, the other part says it's not, but there's a difference of opinion there. This section shall be reused to establish or bring or support a criminal prosecution or civil case of action seeking damages against any person who is immune for liability under this section. What does that mean?
Okay, well, that's
from your perspective as an attorney.
Yeah, okay, as the opposition.
Yes.
Answer.
My name is Susan Swift Arnall, and I'm from the Right to Life League, and we had opposed this bill.
Yeah, actually, you can speak
Pardon
close to
me.
the microphone.
Can you hear me now?
Yes.
Yes,
Thank
for the
you.
record.
I apologize. For the record, my name is Susan Swift Arnall. I'm with the Right to Life League, and I'm a California attorney. We opposed this bill yesterday. What that means is it refers back up to, I believe it's section 123467, which includes A and B of that section. Those two sections, 123467 A and B, are the people, the persons who are immune from prosecution under the statute. And both of those sections, first, section A, refers specifically to the pregnant person, the mother. Section B refers to anyone who aids or assists the pregnant person in obtaining her chosen pregnancy outcome. Therefore, the $25,000 suit that you're talking about in the section, I believe it's 9, applies when either of those entities, the pregnant person or anyone who assists her, is threatened with investigation, because a threat of investigation triggers the Civil Procedure Section 52.1. That's down in Section 9. So it's very clear that that is what triggers the liability for anyone, not medical providers. There's no definition of who these persons are. It is anyone who assists or aids the pregnant person.
Okay, that's the way I read it. The word is anyone. It doesn't, and just so you know, thank you for your response. The bill says anyone. It doesn't say anyone with a license, any doctor. I mean, that might be your intent, but that's not what the language says. And I think that's what Ms. Melendez was getting to yesterday. It might be that, you don't think that it covers outside of the birth of a child, but it does because your bill doesn't say it, if that makes sense.
I appreciate the question.
Sure.
And I understand you're trying to get to clarity on it, and I want to help provide clarity. I'd love to have Ruth come up again and provide clarity on that point, because I think she was about to do that.
All right, Ruth, come up.
Sure. So, so that section is limited in several ways. First, it is limited to, you're correct, someone who aids or assists a pregnant person in exercising, quote, their rights under this article.
So can you just point me to where you're reading so I can follow along?
Sure.
Is that okay?
Again, that is section 123467B.
Right here. Okay.
Okay.
It is protected.
Okay, sorry. Go ahead. I'm there now.
Sure.
Go ahead. I apologize.
So limited to in several ways. First, the section is limited to someone who aids or assists a pregnant person in exercising, quote, their rights under this article. It is further limited based solely on their actions to aid or assist a pregnant person in exercising their rights under this article. And third, this protection is all contingent on the pregnant person's voluntary consent. So as I mentioned before, anything that is against that person's consent or negligent or otherwise unlawful would still be subject to other liability. It is cabined in those three ways.
Thank you.
Okay, well, it still says notwithstanding. It still says anyone. So, okay, we'll disagree on that motion or agree to disagree. I guess, and I know this is like not going anywhere, but just for kicks. This would solve all of this. I mean, it really would. It would solve the whole thing, and I think it would really address a lot of things with the opposition. Again, I know you're trying to get it out of here today, and it's going to get out of here today, but if there was an amendment to amend Section 7 of the bill to add the phrase or something thereof, right? This section shall not apply to babies born alive as a result of an abortion, whatever, right? But the whole thing is that it appears, and based on where the bill started, that the intent is to, the intent of the bill is to just make sure that, individual babies that are born alive, it doesn't matter. It doesn't matter what happens to them within that definition of the World Health Organization and other definitions out there with the American Medical Association and all those definitions that have different time periods. And because you don't identify it in the bill, I really think that even though your intent is to not include that, there are lawyers out there that will take advantage of that in this bill. And my fear is that there will be a lot of individuals, whether it's a botched abortion, a baby born alive, the woman in the Tulare County Jail that beat her stomach and the baby was born alive for, lived 7 minutes or something, but she was like 7.5 or 8 months pregnant. She beat her stomach so bad she induced an abortion. So just those things. I just think that without the bill drafted the way it is does not clarify all those things, which creates great confusion and great concern.
All right.
Okay. Thank you, Mr. Chair.
Thank you, Senator Grove. Are there other questions or comments from members? Senator Wiener.
Just very quickly, I think there are words that are so obvious in what they mean that you don't have to have a legal definition. You don't have to have a legal definition of the word bird. We know what the word bird means, or what the word table means, or what the word state capital means. We don't have legal definitions because that's what they mean. And the word in utero, or the phrase in utero, I don't have the slightest doubt about what that means. It's crystal clear, and I went and confirmed in the dictionary. It means there are two definitions of in utero. The adverb is in a woman's uterus. The adjective, and I think it might be reversed, is happening before birth. So either happening before birth or in a woman's uterus. So I fully support this bill, and I thank the author for bringing it forward.
Okay, thank you. Any other questions or comments? Seeing none? Okay.
Okay,
Yes,
it'll be
comments.
brief. Thank you. Okay, so the problem, largely the problem with your bill is that word perinatal. I will tell you that, and I think you know that. And from what I understand, there's been a refusal to remove that word from the bill, which would probably solve all of these problems. But the bill does say that a person's not subject to these penalties or liabilities due to causes, perinatal death, due to causes that occurred in utero. So perinatal death could be the baby died while in utero. It could be the baby died after having been born. And it refers to, or it speaks to based on actions or omissions with respect to their pregnancy outcome. Okay, birth is a pregnancy outcome. That is according to the National Institute of Health, actually. They talk about pregnancy outcome is a vaginal birth, a cesarean birth, a baby that's born healthy, a baby that's born, with some birth defects or anomalies. It covers all of those things. So this bill seems to shield anyone who, or the mother, I guess, who, omits care from that infant once they are born. That's how I am reading this. That's how many other people are reading this, and I know that you disagree. But I stand by my comments that this is really opening the door to allowing people to operate in a space they are not authorized to operate in, and authorizing women to do harm to their babies and not face the consequences of the law. And I get what you're trying to do, because I understand. I read the cases that you were talking about. I totally understand what you are trying to avoid. The problem is your bill has gone far beyond that, and I am just stymied by the fact that the one thing that could fix this is removing some of these words from the bill, and you haven't done so. So with that, I clearly will not be supporting the bill, and I just wish that you had more interest in fixing, working with the opposition and fixing the problems with the bill. Thank you, Mr. Chair.
Thank you. Any other questions or comments? So Senator Wicks, thank you for bringing this bill forward. I appreciate the work that you've done with the opposition. You got the Catholic Conference off, right? I think that shows that the work that was done. This bill, of course, has been heard in the Judiciary Committee, where we addressed many of the legal issues that we've also discussed today. Of course, we're here in the Health Committee, but I think it's important we don't criminalize people for being pregnant. And so with that, I'll be supporting the bill. Would you like to close?
Just appreciate, Mr. Chair, your work and your committee staff and the conversation here. Obviously, it's an important one. I've worked with opposition. We've clarified language. We've added in utero because of some of the questions that were raised, which did get some of the opposition off. But we may just have an ideological disagreement here with some of the folks on the dais. I'm committed to ensuring every birthing person in the state of California or people that come from other states have access to reproductive care. I'm committed to ensuring that people are not criminally prosecuted for any kind of pregnancy loss of any kind, and we have seen this happen in California. As mentioned yesterday, Adora Perez spent 4 years in prison, and that might not seem a lot like to some folks here, but that's a lot to me, and it's a lot to her and her life. So I want to make sure that we ensure that that never happens again. So with that, I respectfully ask for an aye vote.
Thank you. The motions do pass and re-referred to the Committee on Appropriations. It's been moved by Senator Eggman. Secretary, please call the roll.
Han?
Aye.
Han, aye. Melendez?
No.
Melendez, no. Eggman? Aye. Eggman, aye. Gonzalez? Grove? No. Grove, no. Hurtado? Not voting. Hurtado, not voting. Leyva? Limon? Aye. Limon, aye. Roth?
Aye.
Roth, aye. Rubio?
Aye.
Rubio, aye. Weiner?
Aye.
Weiner, aye. 6-2.
Okay. The vote is 6-2. Hold the roll open for absent members.
Thank you.
Thank you.